Hello, everyone, and welcome to week 3 in this lecture video. I will talk about negotiation. And again, this is your unit coordinator and lecturer, Dr. Manju Oison. Negotiation is a topic that we're all familiar with. When I created the lecture video, I think in week 1, I mentioned two things that are quite permanent in life. One is death, and the other one is taxes. But actually suggested a third permanent feature in life, and that is conflict. Conflict is something that we witness almost every day, and certainly something that we regularly see in our lives. But there's actually, I think, a fourth feature in life that is quite common, and that is that we negotiate all the time. So even as kids, we would probably be negotiating with the parents about, when we should be sleeping. We would probably be negotiating about the food we eat, about when bedtimes ought to be, or whether or not, we should even have to take a bath and so on. And as we grow older, as we become parents ourselves, these types of negotiation is playing out in relation to our own kids. And oftentimes, it is our kids that may drive a very, a strong and hard bargain when they say, I'm gonna do my chores if, you agree to allow me to do this or that. There might even be negotiations about whether or not kids could drink, whether or not they should have a tattoo, whether or not, your 12 or 14-year-old daughter can have a boyfriend, or your 12-year-old son can have a girlfriend. And so negotiation is something that is quite common to all of us. We negotiate almost a lot of times when it comes to, a desire to purchase a house. It could be purchasing a second-hand car. It could be negotiating a raise. It could be negotiating an employment contract, and so on. And certainly, we negotiate a lot with our own partners and our own spouses about, who does this and that, who pays for this and that, how often do we go out, how do we deal with friends, and so on. So negotiation is something that is quite common. However, you probably agree with me in saying that for a lot of us, including myself, we often are very poor negotiators, mainly because we have not fully understood that there are principles we could use in order to become better negotiators. And negotiation is a very important topic, especially for lawyers and would-be lawyers, because negotiation, as we know, is one of the ways by which disputes could be resolved. So it's an alternative dispute resolution. It is one way by which parties are able to resolve a dispute outside the court system, or without getting a determination to be made by a judge. And in the field of law, negotiations happen quite often. For example, in terms of negotiations about settlement, when there is an accident and you have a tortious claim, negotiations can happen in relation, for example, to property settlement. When a couple decides to separate, there are often negotiations in relation to custody over children, or care arrangements over children, and so on. And so we realize, therefore, that negotiation is an avenue by which we could resolve disputes. So this is a topic that could be very, very important for us. So on completing this topic, you should be able to discuss and explain the fundamentals of negotiation. We're also going to be going through the 4 key models of negotiation. And you'll be able to identify the significant elements of the negotiation process, the benchmarks and benefits of principled negotiation, and the considerations in choosing a negotiation model. So let's begin by talking about negotiations. As we said, if there is a matter and there is a dispute that is likely to go before the courts, oftentimes, there is a requirement that the parties must first undertake mediation. But in the context even of mediation, the parties often negotiate. So negotiation is often subsumed within the process of mediation itself. Or otherwise, even if there is no mediation involved, and either the parties themselves try to seek a resolution of a dispute without having to go to lawyers, or it can be where lawyers might be involved. But in any event, the parties or the parties' lawyers often have to negotiate in order to resolve a dispute. And one of the main advantages, of course, of negotiation is that the parties have a chance of getting what they hope to achieve, because in that sense, they're able to craft and come up with a solution to a dispute, which enables them to come up with unique solutions to resolving the dispute instead of relying on the cut and dried solution as maybe laid down by the law. And so the advantage, of course, is that instead of relying on a judge to make a very objective uh, determination about a legal matter, the parties are in a better position to make some adjustments, looking at the idiosyncrasies or the uniqueness of their situation, so that they could end up with a resolution or a settlement that they can, that they can live with. The solution may not often be the best, it may not necessarily be ideal, but it's something that the parties at the end of the day can probably say that they can live with it, because they've considered all the possibilities, they've looked at the pros and cons of the respective positions of the parties and the interests involved in those positions, and at the end of the day they believe that they've come up with a solution that they could certainly live with. The other benefit of negotiation is that the parties are actually in the best position to assess the impact of any proposed solution, because the parties are, live the conflict, because the parties live the dispute. They know all the ramifications. They are very intimately aware about the impact of failing to resolve a dispute, or the impact of any solution that they are able to craft. And it gives them, therefore, the best opportunity to try to find a way to resolve a dispute, rather than leaving it to a third-party person to make a decision for them. A person is certainly not invested in finding a way to resolve the dispute that really satisfies the interests and concerns of the parties. The other benefit of negotiation is that the parties are able to own the process that they agree upon. So when you talk about negotiation, negotiation isn't just about the outcome of the process of talking with another party. It's actually being able to determine the process by which a resolution of a dispute may be arrived at. So it's very important that when we speak, for example, of negotiation, we need to remember that it's not just about positions, it's not just about legal rights, but it's also about not losing face. It's also about being heard. It's also about being able to vent your own emotions, being able to have the chance to discuss an important matter with with an adverse party, rather than not being heard. The other benefit, of course, of negotiation is that, as I mentioned, the parties are able to create their own solution, and therefore they can be more committed to it, rather than having a solution or a resolution that is imposed by someone, because the parties are actually involved in the process of crafting a solution. They can have ownership over it, and because they have ownership over it, because they've invested time and energy in arriving at that solution, then they will probably have to find a way to ensure that the agreement is something that they will have to observe as part of a good faith process, in ensuring that because they've committed to a solution, they have to find a way to make it work. The other benefit of negotiation is that the courts often require parties to try to achieve settlement, and the courts will often say that the risk about not being able to arrive at a settlement on your own, speaking to the parties, is that at the end of the day, you may end up with a win-lose solution. In other words, there is one who wins and there is another who loses. And that can be pretty dangerous because it leaves a lot of uncertainty as to who the winner is and who the loser is. And it leads to a lot of uncertainty and fear on the part of the loser, not only because the loser ends up losing the case, but also having to pay for costs, which will often be awarded by courts. And for this reason, it is often to the best interest of parties to try to really seek a way by which a settlement can be reached in relation to a dispute in obedience to the courts, but more importantly, because it is often better that they own the process of arriving, they own the process and the outcome involved in trying to reach a solution. Now, if a solution isn't reached, the parties are often in a better position to define or narrow the issues in dispute, and this can therefore reduce the time and costs of any subsequent litigation. So it might be that the parties are not able to reach agreement in relation to all issues in a dispute, but there might be matters that they're able to reach an agreement with, and which means therefore that they may not have to litigate or have a dispute in relation to what appears to be a very complicated and a very huge dispute that the parties are facing are facing. Now, let's try to get into the models of negotiation. We're going to be talking about the adversarial negotiation, integrative negotiation, distributive negotiation, and principled negotiation. Let's begin with adversarial negotiation, or what we often know to be positional bargaining. Now, this is the type of negotiation that we're all very familiar with. It might be that you're trying to buy a house, and you'd make an offer to the homeowner, to the seller, and you'd probably assuming that the market value of the house, let's say for example, is $500,000, you'd probably begin by offering a low position, and you probably say, I'd like to offer $400,000. Now, in this type of scenario, when you speak of adversarial negotiation or positional bargaining, what often happens is that if the low offer is perceived to be unfair or not a legitimate offer, it can often mean that the relationship early on is eroded. And there is therefore a huge chance that the parties become very untrusting of each other, which means that there will be more difficulty in arriving at a resolution down the road. The main point oftentimes when you speak of adversarial negotiation and positional bargaining is that the parties are intent on winning. So somebody has got to win. And it's often therefore a zero-sum game. There's one there's a one winner who wins everything, and there is a loser. And it's often therefore seen as a win-lose scenario. The way as I mentioned, the way it's often done is that you either stake out a high or low opening position, or demand or offer. It might be that when it comes, for example, to negotiations about care arrangements over children, when it comes to a couple that has separated and who might have minor children, a common low position might be, for one of the parties to say that, because I've always been the primary caregiver, I should have 14 days, every fortnight, or I should have our child 7 days a week. And with that hard or high position, the other party will probably, it will then be easy for that person to make concessions and say, okay, I've started with 7 days, okay, I'm willing to give you 1 day, or I'm willing to give you 2 days, and so on. And because it appears that the one who's driving a hard bargain appears to be offering concessions, then as a way of trying to maintain the relationship, the other parties might have to concede by saying, okay, if you're willing to give up one day, I'm willing to do this and that. But the problem oftentimes as well is that although we've spoken of hard bargaining, there's also such a thing as soft bargaining, where one of the parties, for example, in relation to a couple, which may have a disagreement in their relationship, there might be, one of the partners might go for hard bargaining, but the other one is soft bargaining, attempts a soft bargaining approach, if only to save the relationship. The problem with soft bargaining, however, and when we speak of soft bargaining, it often means that one of the parties is often willing to just give in, concede to the demands, even if they are unreasonable or even if they appear to be harsh. One of the parties will just concede in order to save the relationship. The problem, however, with soft bargaining is that, at the end of the day, that can lead to resentment. One of the parties who's always bargaining softly, willing to make concessions, is that person may end up becoming unhappy because it's always that person having to make some adjustments. And there's always, therefore, the room for abuse of that other party. So on the one hand, there's hard bargaining where, there's somebody who is always trying to push the boundaries in order to win at all costs. When you speak of soft bargaining, you're in a situation where one of the parties is willing to give up everything, if only to maybe to save the relationship. But, at the end of the day, it's still going to be a zero-sum game. It's a win-lose scenario. There's one winner, but, there is a loser. And the problem with positional bargaining is the fact that it begins with positions or it ends with positions. And because you're dealing with positions, there's only so much leeway when you try to move a position. And for those who are doing pushing a hard bargain, they often find it very difficult to make some adjustments or modify their position, because that might mean, kind of a loss of face. If they were saying initially that they're offering $400,000, for example, to buy a house, and then, they have to concede and say they're willing to pay $600,000, it may generate the thinking that, in the very first place, that person never had any legitimate offer, or never had any genuine inclination to try to offer a reasonable bargain. So, and the other problem with positional bargaining is that because you are stuck with positions, the options for settlement become very limited and narrow. It's often like, you can only revolve around that position where you've already made a stake. So that can lead that can lead to great difficulty in arriving at a solution. It therefore leaves very little room for compromise or an attempt at generating options. As I mentioned, it can lead to a loss of face. It often involves a contest of wills, which results in anger and management. So the one who wins is the one who is, willing to show that he is willing to, just go hard and just become very rigid in his position. So in other words, if, in relation to one who is trying to drive a very hard bargain, he's saying, if you want a settlement, then you have to give in to my demands. But again, that is problematic, because it often happens that even if you end up with a negotiated agreement, there might be times when you might have to revisit that agreement, mainly because there are, incidents or scenarios that have not been fully conceived or considered at the time that the agreement was arrived at, and which means therefore that the negotiation isn't just a transaction, but the negotiation actually should consider the fact that even the adverse parties will continue to be in a relationship, in a forced relationship, if you will, even after an agreement has been reached. So, for example, when two parents have separated and they have minor children, even if they may have a consent order, or even if they may have a parenting plan, which they've agreed with over, and the parenting plan, we have to know, is really informal. It can't really be enforced in court. But whether it's a consent order or it's a parenting agreement, there will be occasions when there might be an assertion that somebody is not living to his or her part of the bargain. There might be situations when it is not too clear how a provision of the parenting plan or consent order should be considered. For example, I was advising a client a few weeks back. They had a consent order, and under the consent order, there was a discussion as to the days when a child was meant to spend, equal time with the mom during the school holidays or during the gazetted school holidays. Okay, so that the question was, equal time. The problem, however, was, how do you define school holidays? Would school holidays begin on the Monday when the child no longer has to go to school, and you count that's Monday until Friday 2 weeks after, because that's the holiday. Kids don't have to go to school. Or do school holidays begin on the Friday prior to the day on Monday when there are actually no classes? That became a contentious issue, because there were the mom was planning to take out the kids on a Friday out of state, but the father was actually expecting to have the child on that Friday based on the care arrangements outside of the school holidays. And so when you consider this, you realize that even if it may appear that the parties have reached a settlement, have reached an agreement, it is often the case that it is important for the parties to maintain a level of relationship, because they often have to revisit the terms and provisions of an agreement that they've entered into. And so the problem, therefore, with positional bargaining and adversarial negotiation is that there is the danger that it can damage the relationship so much so that after the agreement has been signed, it will be very difficult for the parties to talk again or try to communicate about the terms and provisions of an agreement. I recall, for example, an instance where there was an agreement entered into to purchase a property. Okay, so the seller sold a property to a buyer, and although they signed the contract, this was an office space in a building, and although they entered into a written contract, and the seller felt that she was cheated, and so what she did prior to the buyer having possession of the property, she removed, for example, the tiles on the floor. She removed some of the bathroom furnishings, which in a sense, which therefore ended up damaging the property. And certainly the seller could argue that it was within her rights to do that prior to the buyer taking possession, because it wasn't, because the sale, for example, was just over the property. It did not, it did not include, certain things, maybe like, the lighting and so on. But that was a very narrow view. And so again, it is important that when we enter into negotiations, arriving at a negotiated agreement in writing, for example, is not the end. It often has to mean that we need to make sure that we're able to preserve the relationship with the other party. Now, of course, positional bargaining is often rights-based. You have a position that you take, and that position that you take is based on your understanding of what your legal rights might be. And so therefore, this is an approach that lawyers are quite familiar with. And lawyers will probably say, this is our legal position because this is our legal right in relation to what the law provides. But again, as I mentioned, positional bargaining, driving a hard bargain, can often damage relationships and the prospects for future engagement. Now, so we talked about positional bargaining and we talked about a win-lose situation or win-lose scenario. In integrative negotiation, the focus is on having a win-win. Okay, so the goal here is that the parties seek a mutually beneficial solution. There is some, in a sense, it can be somewhat adversarial, but because the goal of the parties is to arrive at a win-win solution, they're often willing to make concessions and make trade-offs. But the important thing is that the parties adopt an orientation towards a win-win, that both parties are actually winning in the process. It shouldn't be win-lose. Now, the point about an integrative or win-win negotiation is that the parties actually have multiple overlapping issues. And what it often means is that if there are multiple overlapping issues, what it means is that sometimes the parties are able to give up and make trade-offs in relation to an issue in order to win concessions from the other party in relation to another issue. And what it also means, therefore, is that the parties are often quite flexible in their positions. The focus is still on their positions and trying to engage in cooperative problem solving in order to arrive at a solution that is a win-win for both parties. The focus still is on examining various options, various positions, and potentially assigning values or weights to those options. The parties may actually rank by quality or value the various options to assess their suitability in the mix of solvent options in order to arrive at an integrated solution. So for example, if it's a care arrangement over children, the options might relate to, who has more time during weekends, who has care over the children over weekends, who might have care over the children during the school holidays or during the school days and so on. There might be questions about whether or not one of the parties can pick up the kids from school and so on. And so therefore there are various options at looking at a problem rather than looking at it from a very narrow viewpoint of care arrangements. Because when you look at the concept of care isn't just having the child in your house. Care could be spending time with the child during the day, even though the child may not end up sleeping with a parent at night. When you look, the other option, of course, is questions about child support. And so therefore, the parties, when they consider options about care arrangements, are certainly considering as well the impact of child support legislation. Now, this integrative or win-win negotiation has some similarity to principal negotiation that we examine in a short while, in the sense that the parties work together to find a solution that satisfies their respective needs and concerns. However, principal negotiation looks to options that satisfy a party's interests, which, as we see when we speak about principal negotiation, the focus of principal negotiation, among others, is to examine the underlying interests behind certain options or behind certain positions. But there is commonality, there is some similarity between the integrative or win-win negotiation and principal negotiation, because both types of negotiation seek a win-win solution for all or for both parties. Now let's talk about distributive negotiation. Distributive negotiation is almost quite similar to adversarial or bargaining to adversarial negotiation or positional bargaining, in the sense that it adopts a win-lose approach. It adopts a fixed pie approach in the sense that there's only going to be one winner and there's going to be a loser. With a distributive negotiation, you can look at the word distributive because you can imagine a pie that is fixed. And the way, therefore, that you arrive at an agreement when you go negotiate is to figure out how do you distribute a fixed pie. So the process of distributive negotiation really is about trying to divide up the pie of value. And you could be using a zero-sum negotiation. It's, there's a winner and there's a loser. And the point there is that oftentimes what happens in distributive negotiation, because of the fixed pie mentality, one person succeeds only at the expense of another person losing. So what often happens then is that the parties end up haggling, they engage in the negotiation dance, there's a back and forth exchange of offers. But the point about distributive negotiation is that the parties are having difficulty going beyond their idea that there is a fixed pie. Oftentimes there isn't a fixed pie. It's actually possible for parties to look for options outside the pie. So for example, when you talk about child care arrangements over children, it's not just about who has the child at night. The other important thing might be who actually has the child during the day. And it might work for one of the parties if one of the parties might be working from home. When you speak, for example, about an agreement where, for example, there is a dog, and the parties love that dog, but they have to separate. It may be that one of the parties prefers to have the dog at night, but one of the parties would prefer simply to walk the dog. And so therefore, the important thing about distributive negotiation is really the idea that everything is a fixed pie. You can't go beyond that. And so the parties negotiate, they dance simply around that pie, failing to recognize that there might be other options, there might be other positions, and there might be interests that underlie these various positions. Distributive negotiation is, again, also competitive because the goal of the parties is to try to compete for a bigger slice of the pie. And in order to do that, the parties may often use misrepresentation or they may withhold information. They may even use bluffs or threats and manipulation in order to get a bigger share of the pie. Now, we're not saying that distributive negotiation will often fail. It can be successful, at least for one party, at least the winning party. Now, so we've talked about adversarial and negotiation or positional bargaining. We've talked about the integrative win-win negotiation. We've now talked about distributive negotiation. We're now going to visit what is known as the principled negotiation, which is a form of negotiation that was really developed by Professor Roger Fisher and William Ury at the Harvard Law School. Now, when we speak of principled negotiation, it's called principled because it deals with certain principles in negotiation. And principled negotiation is often linked to what is known as interest-based negotiation. Interest-based negotiation is an aspect of principled negotiation, although it's a very important aspect of principled negotiation. We're going to be examining them in a short while. There are 4 key principles that we need to consider. One is that in principled negotiation, you've got to learn to separate the people from the problem. You have to focus on interests, not positions. You have to invent options for mutual gain, and you need to insist on using objective criteria in terms of choosing the best options in order to arrive at a dispute. Let's talk about separating the people from the problem. What often happens is that when the parties negotiate, it's really very difficult to try to disentangle the emotions. It's really difficult to separate the people from the problem. You can just imagine, what's happening in the world stage today, where if there is a negotiation, for example, between the Israelis and the Palestinians, there are, the history of these societies and their differences in values, the fears that they may have towards one another, often makes it really difficult uh, to just focus on the problem. They have difficulty separating the people from the problem. For those of us who are a bit older, you might recall the deep animosity between Israel and Egypt, especially because around the 1960s, I think in 1967, there was a 4-day war that was fought, was that no, the 6-day war against Israel, which was initiated by Egypt, by Syria, and I think Iraq. But there were 4 countries, I think including Jordan, uh, which simultaneously attacked Israel at that time. And there were even if Israel was a smaller country, and even if Israel had a smaller population as well, not just in terms of geographic area, Israel was quite successful in the was that the 6-day or 7-day war, and they ended up winning a sizable chunk of the area now known as the Golan Heights. And at some point, the animosity between Egypt and Israel persisted, at least the countries, so much so that there was always the threat and the danger of war between these 2 countries. And one of the important ways by which these 2 countries at some point reached a way of being able to live together was when the former Egyptian President Anwar Sadat visited Israel in order to enter into a peace treaty. And this makes us realize that oftentimes when we deal with problems, when we deal with disputes, embedded in these problems and disputes are actually issues concerning people, are issues concerning individuals. And so having this perspective as negotiators makes us realize that you can't really just objectively deal with the problem without dealing with people issues. But at the same time, it makes us cognizant and aware that a successful negotiator using the principled negotiation approach should be able to separate the people from the problem. That's a crucial point, especially when when you're dealing with, as I mentioned, couples who have separated. They have very emotionally charged countenances, and they often, probably don't want to deal with each other, especially if there's hatred. And so, therefore, the way, therefore, to look for a solution to a dispute or to a problem is to just find a way to separate the people from the problem so that you can focus on interests, you can focus on solutions to the problem without getting bogged down about the differences, the history of unfairness, the history of abuse, and so on. So one of the things you need to do as a negotiator would be to try to understand the other person's viewpoint by putting yourself in the other's place. Do not assume as well that your worst fears will become the actions of the other party. Do not blame or attack the other party for the problem. So in other words, you go hard on the problem, but soft on the people. That's the whole point there. You try to create proposals which should be appealing to the other party. You have to acknowledge emotions and try to understand their source, understand that all feelings are valid, even if you do not agree or understand them. You have to allow the other side to express their emotions. Try not to react emotionally to another's emotional outbursts. You must be able to make symbolic gestures such as apologies or expressions of sympathy, which can then help to diffuse strong emotions. You must be able to actively listen to the other party. In other words, give the speaker your full attention, occasionally summarizing the speaker's points to confirm your understanding. And when speaking, you have to direct your speech towards the other party and keep focused on what you're trying to communicate. You should avoid blaming or attacking the other person, speaking only about yourself, and think of each other as partners in negotiation rather than adversaries. So what it means is that even if there might be disagreement between the individuals, and there is a disagreement as well in relation to the problem itself or in relation to the issues or the disputes, you need to separate the two. and you do not allow the fact that there is a problem in terms of the relationship, you don't prevent that from arriving at a way of settling the dispute. The other important point, really, in principal negotiation is that you have to focus on interests, not positions. So when another party, for example, adopts a position, for example, the party might say, I want the house, or I want our daughter to stay with me, 7 days a week. Behind those positions are actually interests. Why would one or the parties want the house? Is it because it has an economic value in the sense that that's an investment that could be sold, or is it because there is a sentimental value to the house? In other words, if to one person, the house has sentimental value, and you approach it from the viewpoint of purely a financial investment, then there is a mismatch in terms of how the position is perceived in terms of the interests of the parties. When it comes, for example, to care arrangements, when one of the parties says, I want our daughter to stay with me at night, that's a position. But what is it that underlies that particular position? What is the interest behind it? Is it about being able to have somebody at night, being able to spend more time with the daughter at night? Because yes, if the interest, for example, of one of the parties is being able to spend time with the daughter at night, then it's likely possible that that parent is then prepared to concede that the child can spend more time during the day with the other parent. And so one of the goals, one of the goals of principal negotiation is to focus on, if the focus is on interest rather than on positions, is for the parties to ask why the other party is holding the position he or she does, and consider why the party does not hold some other position. So the goal there is to try to have a better understanding of the position taken by one of the parties and figuring out what exactly is the interest. It might be important to try to find a way to get these interests to surface, because by talking about interests, you go beyond mere positions. By looking at interests, we see that a position, when you have a stated position, there are actually a lot of underlying interests involved. And it may be easier for the parties to arrive at a settlement by trying to address those interests rather than really getting stuck by dealing with certain positions. You might also, in principal negotiation, you might also explain your interests clearly. I am adopting, for example, this position because this is my interest in it. This is the reason why. And so, there's an opportunity for both parties to understand the interests or the motivations or the drivers for the positions that they've taken. Now, these interests are then discussed with the purpose of looking for a desired solution, in the future, rather than focusing on past events. And the focus is clearly on interests. But the parties are often, it's important for the parties to be open to different proposals and positions. Another important principle in principal negotiation is to be able to invent options for mutual gain. So again, the problem with the position is that the position often involves a fixed pie approach, a win-lose approach. And so therefore, if there's just one position which is pretty static, there's very little wiggle room outside of those positions. The goal with principal negotiation, having an idea, an understanding that underlying or behind a position is often an interest. The goal then is to try to invent options for mutual gain, brainstorm for all possible solutions to the problem. I recall the wonderful video that was prepared by Steve Pervinas, one of the students in our course, in our unit in alternative dispute resolution. He mentions in his lecture video that when they were negotiating, for example, with Qantas, and Qantas had made the decision to cut costs. The Qantas at that point had grounded, the Qantas fleet. They wouldn't allow any of the pilots to take off and allow the planes to fly. And Qantas, as a way of cost cutting, was trying to remove from the workforce about 6 to 6, airline employees who happened to have been um, members of the union, which was headed by Steve Pervinas. And the other point mentioned by Steve was that the Qantas was looking for a way by which one of the unions would agree to, enter into an agreement with him. And the way that, and I could have, been wrong in the way that I understood the video, the wonderful video of Steve. But one of the options they said was that they were willing to allow a wage freeze as part of the, cost-cutting measures of Qantas, on the condition that the 66 employees who were part of the union, instead of them getting fired, if they were allowed to keep their jobs, then they would be willing to agree to a wage freeze, something that some other labor union would have been willing to enter into in the first place. But the point there is, instead of getting stuck with positions, it's either you fire these workers or not, or wage freeze or not. It's really brainstorming and looking at possible options in order to have mutual gain. The goal as well is to evaluate the ideas only after a variety of proposals have been made. The parties often start evaluations with the most promising proposals, refining and improving proposals at this point. They focus on shared interests, because the moment you have allowed the interests or the drivers or the motivations behind positions to surface, you often are able to see that there is a shared interest. For example, for parents who have separated, they have a shared interest in the growth and the development of their children, that the children feel loved. But at the same time, they have a shared interest in ensuring that each of the parents, has a good relationship with the child, because a good relationship with the child is very important to the emotional and mature development of the child. So you focus on the shared interests. And even when the parties' interests can differ, they seek options whereby those differences can be made compatible or even complementary. In terms of inventing options for mutual gain, the parties often also make proposals that are appealing to the other side, and with which the other side would ultimately find ease in agreement. In other words, the parties not only are attempting to arrive at a win-win solution reflecting the integrative win-win negotiation approach, but at the same time, it is really having that idea that it is an agreement that both parties can live with, because the agreement embodies the shared interests of the parties. The agreement embodies the understanding of the parties involved about the interests that motivate both parties towards a settlement of a dispute. In principal negotiation as well, it's important that the negotiators or the parties identify the decision makers and target proposals directly towards them. Now, the fourth principle in principal negotiation was insisting on the use of objective criteria. So, as we said, you move away, you move beyond positions and try to determine what the interests are that underlie those positions that have been made. But at the end of the day, when options are being considered, options by which the parties might be able to reach an agreement, the question then is, how do we choose which options should be the focus of an agreement? The goal then is to use objective criteria, which means, and some of the objective criteria might be in relation, for example, to a property settlement, who gets what, superannuation, for example, when superannuation is also considered, you might consider an objective criteria such as market value. You might also consider precedent. How has something like this been resolved in the past? You might also use scientific evidence, professional industry or ethical standards. You might consider standard form contracts, cost estimates, legal rulings, and tradition. And so with that, on completing this topic, you should be able to discuss and explain the fundamentals of negotiation, the 4 key models of negotiation, the significant elements of the negotiation process, benchmarks and benefits of principled negotiation, consideration in choosing a negotiation model. And with that, I thank you for listening and watching this lecture video on negotiation. Thank you. Bye.